Yes, sorry to keep you waiting.
May it please your lordships and your ladyship, I appear with my learned friend Camilla Lamont for the appellants, my learned friends Jonathan Seekler Casey, David Taylor and Lemuel Lucan Wilson appear for the respondents. I think I should start by acknowledging that in various respects this was a challenging case for the judge, and for much of the judgment the reasoning cannot be faulted. But the judgment went badly wrong by failing to apply the principle, I'm quoting here from the Cape Town case, that a man cannot increase the liabilities of his neighbour by applying his own property to special uses. And as we will explain, that is not a freestanding principle. That principle is fundamental to the way in which the common law upholds the rights of owners of land. And so by failing to apply that principle, the learned judge failed to uphold the second appellant's rights as a landowner. So that principle means, as we say in our skeleton, that if an observatory is disturbed by artificial light, the observatory needs to locate itself in the middle of a moor. The observatory is not entitled to locate itself next to a village and insist that the villagers switch off their lights throughout the night. London Zoo must own many sensitive animals. It has chosen to locate itself at Regent's Park, well away from homes and businesses. London Zoo would not be entitled to relocate its giraffe enclosure to Kilbert and to insist that to avoid the giraffes being disturbed by noise during the breeding season, neighbouring homeowners cannot mow their lawns using an electric lawnmower. A precision engineering business whose work is disturbed by vibrations should locate itself in a big plot of land at a spacious industrial estate. The engineering firm is not entitled to locate itself within a few metres of a neighbouring building and to object if the owner of the building carries out renovation works that involve drilling. Like those examples, this case is a textbook illustration for the application of the principle. And what I propose to do in my submissions is to first to address you on nuisance, then to address you on negligence. I'm then going to hand over to my learned friend Miss Lamont, who will address you on the Canadian mink farm cases. And I can say that we do not pursue our ground of appeal complaining about how the learned judge exercised his discretion on costs. So turning to negligence,
It would help us, I think, if you, because we do have 2 days, and I don't know whether you're planning to or not, to actually take us through the case in some detail, including the pleadings, the judgment, to understand it perhaps more fully than we do at the moment. So rather than, I don't know whether you're, because it sounded as though you were going to jump into the law, and actually having a better grasp of the background, as I say, the pleadings, the structure of the judgment, the findings the judge made, and so on.
It's correct to say the judgment is not especially user-friendly. And it took me 2 or 3 times to sort of figure out what's going on. What I propose to do is to start by sort of focusing in on the legal mistake that we say the judge made, focusing narrowly on that. But then I'm going to, slightly later on in my submissions, explain, to take you in more detail through the allegations, how it was pleaded, and all of that. So I think I will do that.
Right.
But I would like initially to focus quite narrowly on the error we say was made. But I am going to do exactly what your lordship has asked.
Thank you.
So our first criticism and most basic criticism of how the learned judge dealt with the nuisance claim is that the learned judge applied the wrong threshold test for ascertaining whether the interferences caused by noise and the digger's bucket were sufficiently serious to be capable of being a nuisance. So rather than asking whether the noise and the digger's bucket had substantially interfered with the utility and amenity value of the third respondent's land, which is the correct test, the learned judge instead determined whether the noise and digger's bucket had created a sufficiently serious interference with the third respondent's land to be capable of being a nuisance by reference to the impact on the third respondent's sensitive business.
Can you help me with where this comes in your grounds of appeal? Because it struck me that...
Yes, we've said he invented the principle.
It's your ground 2, is it? This is an articulation of your ground 2. So, but I'd understood your ground 2 to be the point, which I absolutely get from your skeleton.
Yeah.
But you say the judge went wrong because what the claimant had was a sensitive trade, and the judge invented a principle to get around that.
Exactly. He's qualified the threshold test by inventing a principle that it doesn't apply if a sensitive trade is at a suitable location.
Right.
And we see that if we the passage.
That's not the point you that's not quite the point you just made now. Your criticism was that the judge applied the wrong threshold test for sufficiently serious to be capable of being a nuisance, and then you looked at the noise and the digger bucket.
Yeah, he failed to apply the proper threshold test, whether it affected the utility and amenity value of the land, and he instead determined the nuisance claim by reference to a threshold test based on the impact of the business. And the reason he did that is because he, as I say in the second round of appeal, he invented a qualification to the sensitivity principle that it doesn't apply where the sensitive business is at a suitable location. So, turning to page 88 of the core bundle, At paragraph 53 of the judgment, the learned judge distills a set of propositions from Lord Legate's analysis in Fern. And you'll see the first principle is that the law of nuisance is concerned with the wrongful interference with the claimant's enjoyments of rights over his land. This extends to any buildings upon it and to rights pertinent to his ownership interest. The focus is on the diminution in the utility and amenity value of the land as opposed to harm to the person. So he's got it right there. Page 89, point 4, he then says any decision that the defendant's activity is unlawful and therefore constitutes an undue or unreasonable interference with the claimant's enjoyment of his land must at the first stage rest upon the twin-limbed conclusion that there's been a substantial interference with the ordinary use of the claimant's land. Then 4 lines on, that the defendant's activities must interfere with the ordinary use of land is aimed at eliminating unjustified claims which are instead founded upon interference with the use that is out of the ordinary. Lord Legate endorsed the observations of the Privy Council that a man cannot increase the liabilities of his neighbour by applying his own property to special uses, whether for business or pleasure. This limb of the test therefore requires the court to consider the type of property in question within its surrounding neighbourhood, the locality principle. It's contrary to the notion of give and take that a claimant should, by using his land for purposes beyond the ordinary and which carry with them particular sensitivity to his neighbouring activity, increase the potential liability of his neighbour under the law of nuisance.
Do you agree with that, don't you?
I raise a slight question mark relating to his reliance on the locality for this purpose. That's quite a difficult issue. Nothing turns on that for the purposes of this appeal.
Okay. Speaking for myself, this is pretty important. So this direction of law 4 seems to me to be very close to the issues in the case.
Yeah.
He, certainly the judge, comes to the very principle you started with. It's in italics.
Yeah.
You can't increase the liabilities of your neighbour, etc. So can I invite you to you've raised a flag about reliance on locality, but in which you may want to expand on, but otherwise, is this a correct statement of the
Yes.
court drawn from Fern, your contempt?
Yeah, yes. Yeah. Up to the words this limb, that's all correct. And I'm just raising a question mark to do with his reliance on the locality principle. Nothing turns on it in this case. So over the page to page 90, the judge says at the foot of the page, page 56, the locality principle forms a central part of the present case in which the falcons in the aviary are sensitive animals. As I read the decision in Fern, a special use which involves a claimant placing the principles of reciprocity and give and take under excessive strain forced to be identified to what is not the common or ordinary use of his land having regard to the locality.
I'm so sorry I've lost you. Where are you?
So that was paragraph 56 at foot of page 90.
And that's right too, isn't it? You'd agree with that?
Again, I'm placing a little question mark alongside the reliance on the locality, but nothing turns on that for this case. Paragraph 57, he says, considering the position in relating to the defendant's use of his land, in Sturge's in Bridgman, Lord Justice Thesiger reasoned what would be a nuisance in Belgrave Square would not necessarily be in Bermondsey. And that was often taken to mean that the threshold test for whether an interference is sufficiently serious to be a nuisance would be different, i.e. lower in Bermondsey than in Belgrave Square. But as Lord Legate explains in Fern, I can give you the page references, page 958, 959 of the authorities bundle, that's not correct. What this is getting at is whether there is a defence to a nuisance claim, so an activity has hit the threshold, whether there's a defence on the basis that the defendant is making a common or ordinary use of land.
judged by locality. Isn't
Exactly, and why Bermondsey is in there is because Bermondsey is where the tanner
It's
is.
industrial.
It's particularly tanneries. So tanneries give off a unpleasant odour, and so the point is that whilst you do have a defence to an odour claim in Bermondsey, because if you're a tannery, because that's part of the common and ordinary use of land, you wouldn't have in Belgrave Square because it's not.
Which is residential.
Yeah. Paragraph 58, in my judgment, is not open to the court simply to categorise the claimant's use of land as special or sensitive one, interference with which will not support a claim in nuisance, without considering whether it is too sensitive for the surroundings where it is taking place. Then 59, he says otherwise.
But do you agree with that? That's right, isn't it? I mean, you might quibble with the language of too sensitive for the surroundings, but...
No, that's completely wrong.
Statement of
That is completely wrong.
Okay.
The test is a sort of abstracted test of whether there's a substantial interference with the utility and amenity value of the land. That is not the test.
Isn't he dealing with the Bermondsey and Belgravia point here?
No.
Okay.
No, this is from the other point of view. This is from the point of view of the claimant. Paragraph 59 is completely wrong. This is common ground. The judge says that otherwise there would be certain uses of land, including business or trade use, which, regardless of the character of the surrounding neighbourhood in which the use took place, would be unprotected by the law of nuisance, save possibly in a case of malicious interference with that use. To take an extreme example, if the operation of two separately owned aviaries on adjoining land in the middle of nowhere each constitutes a special use, even if, as the presence of both indicates, the locality is an ideal place to breed falcons, the owner of each aviary would not benefit from any protection by the law of nuisance against other avian activity by his neighbour, however intrusive and heedless they might be, which substantially interferes with the breeding business. Well, that's common ground, that's incorrect. Then he goes on, although I understood part of counsel for the appellant's argument to be that the third respondent cannot maintain a claim in nuisance because its falcons are particularly sensitive, in my judgment, Fern does not support such an unqualified submission. Then if we turn to page 100...
And you say that's wrong. I'm just trying to work out where you say he goes wrong. And 58.
Where he really goes wrong is, I'm just coming to.
But can I, sorry to keep, it's important, certainly speaking for myself, because he's talking about these principles. I've got it marked that you think 58 is wrong, 59 is wrong. Can I have your submission on 60? Is 60 wrong or right? Where he says that he doesn't think that Fern supports that unqualified submission.
It does support that unqualified submission. We see where it really goes, really the crux of where the judge goes wrong at page 150 to 151.
Sorry, 150.
So at the foot of the page, paragraph 327, any finding that Mr. Thomas and or UCE is liable in nuisance must begin with consideration of the potential impact of the locality principle. And then over the page, this is where the crux of it. Paragraph 332, a business operation such as the third respondents could of course be built in the middle of nowhere, such as the top of an isolated moor, but it does not follow that the aviary is not suited to its own location. On my understanding, its location is no less rural and possibly more so than Mr. Garland's successful aviary, Mr. Garland being my client's expert, the defence from which from disturbance on neighbouring land. Sorry, Mr. Garland was the respondent's expert. I think my learned friend is saying, the defence of which from disturbances on neighbouring land, Dr. Forbes, who is my client's expert, has himself supported. Here's the paragraph, the crucial paragraph, 334. The evidence about the location of Mr. Garland's own aviary, Mr. Bryn Close's aviary, and Mr. Forbes, my client's expert, was cross-examined about a report he'd written in respect of Bryn Close's aviary, the history of Martin's breeding of falcons at the site before the aviary was built, and the overall success of the third respondent's business in breeding birds all point to this being a suitable location for the sensitive operation of breeding falcons. So he's acknowledging that breeding falcons is a sensitive business, but he says it's a suitable location, and that's reflected in what is said in 332, suited to its location. And it is that finding that leads the judge to determine the claim not by the correct threshold test, but instead by reference to the impact on the sensitive falcon business. And we can see that at, start off at page 90.
Just before you do that, is 334 wrong as a matter of fact? I understand your criticism that having said it's a suitable location for breeding falcons, he equates that with, therefore, it's not a special use for the purposes of the principle.
Yeah.
But he could be right as a matter of fact that if you're going to breed falcons somewhere, doing it in Cornwall is as good a place as any to do it.
Well, it'd be better next to, given how the law is, it'd be better next to, for example, a park or a moor or a river, which involves, on which normal activities wouldn't be carried on, which would disturb the business. It would be better if you had just a sufficiently large area of land that you own all the land around it and have control over it. It would be better if you had a restrictive covenant over any neighbouring land where there might be normal use which would interfere with the business.
So what you say, he was wrong to say it's a suitable location. It's not suitable precisely because it's very sensitive.
I say that the test of whether it's a suitable location is not the correct test. I find it very difficult to attach much content to the idea of what criteria are meant to apply to work out what is a suitable location, but it certainly wasn't a sensible location for the owner of an aviary, given how the common law vindicates the rights of land ownership and how the principles of nuisance operate.
But aren't you stepping ahead? I think what's said against you, we might as well just flush it out now, is that it's around about this part of the judgment where the judge, he's effectively concluding that it is a common and ordinary use of land to have an aviary in that part of the countryside.
Well, I mean, I am going to come on to deal with that, but I mean, if you're my learned friend doesn't really engage with what I'm saying now. He doesn't try and defend the fact that the learned judge has attached this caveat or qualification to the sensitivity principle. What he says is, in fact, what the judge has done is to apply the proper test.
Yeah, he says it's
He's applied the proper test of whether the use of the second appellant's land substantially interfered with the utility and amenity value of their land. That's basically what he says. But I mean, I want to come on to this more in more detail later, by reference to the facts. But I mean, think about the digger's bucket. Can it be suggested by having, I'll show you photos of it in a moment, can it be suggested by having a digger on your land with a bucket in the air would substantially interfere with the utility and amenity value of the neighbouring land? I mean, that's ridiculous. But I want to come on to that in a moment. If we can now turn to page 83 of the bundle. So we're looking at how the claim in nuisance was put. It's paragraph 41, and I'd ask you just to glance over it. You'll see it's all about the impact of the digger's bucket and the noise on the third respondent's business.
So you're saying it's sort of reversing it, that excessive is excessive by reference to what falcons at that time of the year can cope with. Don't we?
Yeah.
So how loud is 70 decibels?
I've no idea.
No. And was there any evidence about it?
I think there was some acoustic evidence, but I'm...
No.
there wasn't.
Okay. It doesn't feature in the judgment, does it?
And no recording.
But I mean, 70 decibels there's a footnote somewhere in the pleading, which I think I'll take you to in due course. 70 decibels is the amount of noise within the aviaries that disturbs the falcons.
Yes.
So the point is, it's all about
Yes.
the impact on the business.
Yes.
And so then you go forward to page 158. And when the judge comes to this page 158 to 163, when the judge determines whether the claim in nuisance has been made out, it's all about the impact on the sensitive falcon business.
Sorry, what page was that?
It starts at page 158. So allegation 1 is to do with the scaffolding. Allegations 2 and 3 weren't made out. Allegations 4, 5, 6, 7 and 8 were to do with the building of the barn. But it's all to do with the impact on the sensitive business. And the conclusion is at page 163, at paragraph 395, where the learned judge says, even though malice has not been established, the proven acts of nuisance are, in my judgment, actionable because they were undertaken without proper consideration of the sensitivity of the third respondent's birds during the breeding season.
And that's all to do with the conveniently done rider, isn't it? In firm and older cases.
No, this at the point that I'm addressing now, it's got nothing to do with conveniently done. This is the threshold question of whether the interference is sufficiently great to be capable of being a nuisance. And so what we've seen is the judge has added a caveat or qualification to the principle that whether something's a nuisance is to be judged not by reference to its impact on a sensitive business, but instead on the utility and amenity value of the land. He's added a caveat by saying that the principle does not apply if the sensitive business is carried out at a suitable location. And the judge thought that the aviary was at a suitable location. It was reasonable for the third respondent to locate its business at that location. And so whether the appellants were liable in nuisance fell to be judged by reference to the impact on the business. Now, for 5 reasons, we say the judge was wrong to add that caveat or qualification to the sensitivity principle. And my first reason is that a submission arguing for a similar caveat or qualification was rejected by the Court of Appeal in the leading case of Robinson and Kilbert.
This is the brown paper case.
It's the brown paper case, famous case, textbook case. It's at divider 8 of the bundle of authorities.
I'm sorry, I must just write down what you say, the caveat or qualification which the judge applied was.
So the judge said, what the judge has done is to say he's caveated or qualified the principle that you judge whether the threshold has been met for nuisance by reference to its impact on the utility and amenity value of the land, not by reference to any sensitive business. He's caveated that by saying that doesn't apply if the business is carried out at a suitable location.
And then you can be as sensitive as you like. You can defend, in other words, an interference with a highly sensitive business does create a nuisance simply because you're in what is defined as
suitable location. Exactly. And that submission was rejected by the court in the leading case.
Yes.
So this is Robinson and Kilbert. The claimant was a paper merchant, and the defendant had let.
Sorry, hold on, I got the wrong.
So it's divider 8.
Yeah, hold on. Yes.
Divider 8. The claimant was a paper merchant. The defendant let to the claimant the ground floor of a property to be used as a warehouse for its paper. And we can see at page 64 of the bundle, 65 of the bundle, the start of the passage setting out the facts, that there was a short lease between the parties to take the ground floor of a warehouse in Manchester.
Sorry, where are you?
So by a short agreement in writing dated 28th, and you'll see 6 lines down, the premises, the ground floor of a warehouse in Manchester.
Yes.
And there was a cellar beneath the ground floor, which the defendant landlord retained in their occupation. And the cellar didn't have a ceiling. And there was a boiler in the cellar. And the defendants used the boiler to heat the cellar to provide warmth and air, dry air, to enable them to manufacture paper boxes. But if we look at page 65 of the bundle of authorities at the foot of the page, 6 lines up, about September 1887, the lessors commenced business as paper box makers, for which they required warm and dry air. For this purpose, they used the boiler and set up some steam piping in connection with it, the effect of which was that heat escaped into the plaintiff's premises, and the more so as the boards of the floor did not fit closely. It appeared that sometimes the temperature in the plaintiff's warehouse rose as high as 80 degrees on the floor, but it did not appear from the evidence that the temperature of the general air of the room was often more than 65 degrees and very frequently was below 60 degrees. At page 66, the final paragraph, first sentence, you see the plaintiff brought his action to restrain the defendants from heating and drying the air in his warehouse so as to cause damage to him. So there's a claim for an injunction. The trial judge dismissed the claim. The Court of Appeal dismissed an appeal. What I was referring to is at the middle of page 69, when during argument, Lord Justice Cotton, this is right in the middle of the page, says this. He says, is injury to a very delicate trade a nuisance if it would not injure an ordinary one? And the answer from counsel comes back, yes, if the delicate trade is a reasonable user of the property. So you can see what the claimant was saying. I'm a paper merchant. I have taken a lease of a warehouse in Manchester. A warehouse in Manchester is a suitable location for a warehouse of a paper merchant. A warehouse in Manchester is a reasonable location for a paper merchant's business. Therefore, you should not judge the claim by reference to its impact on the utility of the objectively assessed utility of the premises, but instead on my sensitive business. The counsel refers to a case called Cook and Forbes in support of his argument. That's in the bundle at Divider 3. I needn't take you to it. Suffice to say that that case does not provide any support for the submission. What the case held is that, and we'll see it's discussed in Robinson and Kilbert, what it held is that a nuisance claim can be judged by reference to impact on a sensitive business if the business is affected by something that's noxious. And that is, we're not dealing with anything noxious here, but that is not something that is part of the modern law of nuisance. Lord Justice Cotton, the part of his judgment I'd like to take you to starts halfway down the page, where he says, but no case. He says, but no case has been cited where the doing of something not in itself noxious. Sorry, page 70.
Yes.
Halfway down, but no case has been cited where the doing of something not in itself noxious, so that's a reference to Cook and Forbes, has been held to be a nuisance, unless it interferes with the ordinary enjoyment of life or the ordinary use of property for the purposes of residence or business. It would, in my opinion, be wrong to say that the doing of something not in itself noxious but is a nuisance because it does harm to some particular trade in the adjoining property, although it would not prejudicially affect any ordinary trade carried on there and does not interfere with the ordinary enjoyment of life. Here it is shown that that ordinary paper would not be damaged by what the defendants are doing, but only a particular kind of paper, and it is not shown that there is heat such as to incommode the work people on the plaintiff's premises. Now that's important, that sentence. That is pointing out that it was for the plaintiff to establish that there was a nuisance. And in order to test whether the activity that has caused the interference has not only harmed the sensitive business, but has also hit the threshold test of causing a substantial interference with the objectively ascertained amenity value of the land, a good question to ask is whether it has inconvenienced the people, the employees of the paper merchant. Turning to Lord Justice Lindley, at page 72 of the Bundle of Authorities, top of the page, it says, as regards the question of nuisance, the lessors heat the air of their cellar so as to raise the temperature of the room. He again says there is no evidence to show that the heat is such as to interfere with the comfort of the plaintiff's workpeople. But there is evidence to show that it damages one sort of paper sold by the plaintiff and so, to some extent, interferes with his use of the demised property. And perhaps I could just ask you to read the rest of that paragraph. Then over the page, Lord Justice Lopez, he says, I think the plaintiff cannot complain of what is being done, as a nuisance. A man who carries on an exceptionally delicate trade cannot complain because it is injured by a neighbour doing something lawful on his property. If it is something which would not injure anything but an exceptionally delicate trade, well, that's important. Contrary to what the judge said, that is saying that someone carrying on an exceptionally delicate trade can complain if what is happening would substantially affect the amenity value of his land. In the present case, the defendants are not shown to have done anything which would injure the ordinary trade and cannot, in my opinion, be held to be liable on the ground of nuisance. So that's my first submission. The judge's qualification to the sensibility principle, the first reason why his qualification to the sensitivity principle was wrong is that a submission arguing for a similar caveat or qualification was rejected in Robinson and Kilbert. My second point is that the judge's qualification to the sensitivity principle is inconsistent with the outcome of two other leading cases. And the first of those cases is a divider 9, and it's the Cape Town case. So this was an appeal to the Privy Council from the Supreme Court of the Cape of Good Hope. In 1889, the plaintiff laid a telegraph cable under the sea which landed in Cape Town. And at page 76 of the Bundle of Authorities, the first full paragraph on page 76, in the statement of facts, you'll see it says that the appellants are incorporated under English Companies Acts and carry on the business of transmitting telegraphic messages by submarine cable between Cape Town and Europe. One of the appellant company's cables, known as the Western Cable, after leaving Luanda on the west coast of Africa and after passing through the waters of Table Bay, reaches a cable hut on the shore near the central jetty, Cape Town, whence communication is established by land wires with an office in the Standard Bank building, Cape Town, where the messages are received and recorded and whence they are also dispatched. Now, the defendant, a few years later, opened a tram system in Cape Town, powered by electricity, and we see the impact of the tram system at page 77 of the Bundle of Authorities, halfway down the page. where it said that from the laying of this cable in 1889 until 1896, when the Respondents' tramway system was open, no difficulty was experienced in its working. As soon as this system came into force, disturbances to the signals received from the cable occurred and were so serious a character as to render the working of the cable impossible whilst the tram cars were running. The starting, stopping and alteration of speed of each car was attended by the production of a false signal upon the receiving instruments at Cape Town. And we see at page 83 the paragraph about 2/3 down the page. In order to complete the description of the nature of the injury, it is necessary to add that the difficulty has now been completely got over by laying what is called a twin core cable for several miles out, the two wires rectifying one another's action. Now that this has been done, the electricity from the tramway can pass along the sheathing without harm being done. The cost of the remedial measure forms a large part of the claim in the suit, much of the rest representing experimental and tentative measures. And the plaintiff's main contention was that the defendant was liable under the principle of Rylands and Fletcher. And all I need to say about Rylands and Fletcher is that it is a cause of action closely connected to nuisance. And as Lord Gough explains in the Cambridge Water case, it should be regarded as essentially an extension of the law of nuisance to cases of isolated escapes of land. And the references for that are page 499 to 500 and 507 of the Bundle of Authorities. Now, see at page 81 that the defendant, the tramcar company, relied upon Robinson and Kilbert. So page 81, about 10 lines up, it was argued that neither under Roman Dutch law nor under the common law of England had the appellants a legal right to have their apparatus guaranteed at the respondent's expense on the slightest disturbance, more especially when the appellants could, by taking reasonable precautions, protect themselves. The appellants cannot increase their common law rights by availing themselves of the increased delicacy of the instruments at their disposal or applying their property to special uses. If the respondents were shown to be guilty of negligence, that would impose liability. If the appellants were injured in the ordinary enjoyment of their property, they would be entitled to protection. But they cannot, by reason of the peculiarity or delicacy of their trade apparatus, claim an extension of the principle of Rylands and Fletcher. And that submission was accepted by the Privy Council, with Lord Robinson giving the judgment of the Privy Council. The judge thought that the principle of Rylands and Fletcher applied to the storage of electricity. That's probably not something the courts would say today. But for our purposes, the relevant part of the judgment starts at the foot of page 86. And I'd invite you to read from 4 lines up to describe this, down over to the following page, down to the words about 3/4 of the way down, while agreeing.
Sorry, I'm a bit lost. Can you help me again?
So, starting on page 86, 4 lines up, 5 lines up to describe this, and then over the page, the next full paragraph over the page. The next paragraph over the page.
Yes.
So the key parts of that passage that the plaintiffs could not claim higher privileges than other owners of land and cannot create for themselves by reason, this is about 10 lines down, by reason of the peculiarity of their trade apparatus, a higher right to limit the operation of their neighbours than belong to ordinary owners of land who do not trade with telegraphic cables. And then the passage I keep repeating, that a man cannot increase the liability of his neighbour by applying his own property to special uses. Now, I also note at the end that the judge notes that nor need the law be regarded as showing any want of adaptivity to modern circumstances, for the liability thus limited is of insurance and not for negligence. The remedy of negligence remains. And the judge, obviously this is before the modern law of negligence, but the judge didn't seem to think that ordinary land use is something that could be characterised as negligence. Now, the reason I say that the outcome of this case is inconsistent with the caveating, or the caveat or qualification that the learned judge applied to the sensitivity principle, namely that the sensitivity principle doesn't apply if the claimant is carrying on its business at a suitable location, is because obviously in this case, the claimant telegraph company was carrying out its business at a suitable location. I've taken you to the passage where the cables go to a cable hut on the shore near the central jetty, and they're communicated by land wires to an office at the Standard Bank building, Cape Town. For a cable company providing a service in Cape Town, that was obviously a suitable location. The second case, the outcome, another famous case, the second case, the outcome of which is inconsistent with the qualification that the judge applied to the sensitivity principle, is the Hollywood Silver Fox Farm case. That's at divider 12 of the bundle of authorities. The plaintiff bred silver foxes at 20 acres of land, and at page 178 from the judgment of Mr. Justice McNaughton, the second paragraph, you'll see that he says, in September 1934, Captain Chalmers was minded to start business as a breeder of silver foxes for profit, and with that object in view, he purchased some 20 acres of land and Hollywood Cottage at Kingsdown in the county of Kent. He made a number of pens in which he kept the foxes. He had 13 vixens and 12 foxes. The property acquired by Captain Chalmers is bounded on the north by School Lane, and he erected on the land adjacent to School Lane a board inscribed with the words Hollywood Silver Fox Farm. The defendant is the owner of a large farm on the northeast of Captain Chalmers' Fox Farm. The pens erected for the silver foxes are some 29 yards from the boundary of the defendant's land. So very similar facts to our case. A sensitive business of breeding animals, and it's located next to farmland. Now what happened is that the farmer, defendant, wanted to develop the field next to the fox farm as a housing estate and to sell off vacant plots. But the plaintiff's sign, Hollywood Silver Fox Farm, was visible from that field, and the defendant thought it would put off purchasers of the plots. So the defendant asked the plaintiff to remove the sign, and the plaintiff refused. So the defendant said that if he failed to remove the sign, he would fire a gun near the foxes during the breeding season. And see at page 178, at the foot of the page, about 6 lines up, it was given in evidence that silver foxes breed once a year between the months of January and May, and during the breeding season the vixens are extremely nervous. Any noise such as the discharge of powder is likely to have an injurious effect on them. Such noises may put a vixen off her mating or may cause her to kill and devour her young. So what happened? The farmer sent his son to the boundary, who on 4 successive evenings fired a gun, and that injured the foxes, and the plaintiff, the owner of the fox farm, applied for an injunction to restrain the farmer committing the nuisance, a nuisance of shooting within 100 yards of his land. And at the trial, the defendant claimed he was only shooting rabbits, and the judge disbelieved that evidence. But at page 180, we see that it's just over halfway down that Mr. Roche, who was counsel for the defendant, see, he contended that in this case the defendant has committed no nuisance at all in a legal sense, and he referred to the case of Robinson and Kilbert. And you see, he also refers to the Cape Town case. And then 4 lines from the foot of the page, he says that if it was argued that the keeping of a silver fox farm was not an ordinary use of land in the county of Kent, and what the defendant had done in discharging the bird-scaring cartridges would cause no alarm to the sheep or cattle which are usually found in Kentish farms. So there we are. We again find an example of someone trying to apply the correct test. Has there, in the modern way of expressing it, been a substantial interference with the utility and amenity value of the land? The way of testing that is to say, would it cause alarm to sheep or cattle? So that's a relevant question. And counsel went on, it was only because Captain Chalmers had brought these highly nervous animals, not natural to this country, that had caused the plaintiffs any loss. And if silver foxes were brought to the county of Kent, one could not thereby restrict their neighbours in the matter of shooting. And he says, I'm not satisfied that there is any substance in that argument. It's a perfectly lawful thing to do to keep a silver fox farm. Now, I think the fact that the shooting took place intentionally for the purpose of injuring the plaintiffs made it actionable. So this is the famous case to establish that if you're using land maliciously, that is automatically a nuisance. But if the judge was correct, the judge in this case wouldn't have had to develop the law to include that principle. Because if it's the case that the judge was right to say that breeding sensitive falcons next to farmland is a suitable location for that business, you would imagine that breeding suitable sensitive foxes next to farmland was a suitable location for that business. So if the judge was right, there was no need to resort to malice, and this case should have been decided on the basis that whether there was a nuisance fell to be decided by reference to the impact on the sensitive business. That's my second point.
Yes.
So my third reason why the judge was wrong to qualify the sensitivity principle is it undermines how nuisance upholds the rights of the owners of land. This is a slightly longer point, and but it is really goes to the crux of our argument. And I need to work things out from the first principles of nuisance. The key point in all of this is that nuisance is a property tort whose aim is to uphold and protect the rights of the owners of land. The rights of the owners of land are principally protected by three causes of action: possession actions if an owner of land has been dispossessed, trespass in the case of a direct interference with the owner's right to possession, and nuisance.
You say the owners of land, but all three of those causes of action are available to someone in possession of land.
Yes, you're quite correct, and possession of land is, of course, fundamental to the idea of ownership of land in English law, but you are correct to say.
Unless he is in possession, and
Yeah.
is entitled to bring actions for possession,
Yes.
trespass and nuisance.
Yes, yeah. Perhaps I am using owner of land as a shorthand. It does also include those entitled to possession. And nuisance in the case of indirect interference with an owner's right to possession. There's also Rylance and Fletcher, closely connected to nuisance, and there's some principles specifically relating to water. Now, given that the object of those three causes of action is to uphold and protect property rights, it's unsurprising to see that they impose strict liability for interferences with land. So there's no defence to a possession claim that the defendant reasonably believed they own the land. It's not a defence to a trespass claim complaining about encroachment by a fence over a boundary. The defendant reasonably believed that the fence was on his side of the boundary. Equally, it's not a defence to a nuisance claim that the defendant took all reasonable care not to interfere with the claimant's rights to enjoy their land. And if you could turn to divider 30 of the bundle of authorities, the Cambridge water case. So this was a Rylance and Fletcher case. I needn't trouble you with the facts, but I want to take you to page 500 and the judgment of Lord Gough.
Yes.
So at letter D, he says, of course, although liability for nuisance has generally been regarded as strict, at least in the case of a defendant who has been responsible for the creation of the nuisance, even so that liability is being kept in control by the principle of give and take, which I'll come on to in a moment. But there the judge is recognising that liability for nuisance has generally been regarded as strict. And perhaps just for your note, in Hunter and Canary Wharf, Lord Hoffman, page 535, F to H of the authorities bundle, he also refers to liability and nuisance being strict. Over the page of page D, the learned judge refers to three ways in which liability for nuisance, strict liability and nuisance, is qualified or tempered. So at D, he says that in the present case, we are not concerned with liability and damages in respect of a nuisance which has arisen through natural causes or by the act of a person whose actions the defendant is not responsible, in which case the applicable principles of nuisance have become closely associated with those applicable in negligence. So if the defendant himself has been directly responsible for the activity that has interfered with the use of the neighbour's land, liability is strict. But where something has arisen on the land, such as something caused by, such as a natural hazard or something created by trespassers, instead the defendant is under a duty to act reasonably in order to deal with the hazard. And I'd just as really an aside, I'd point out that whilst the judge says that the principles in that case have become closely associated with those applicable in negligence, in fact, those principles have nothing much to do with the principles of negligence because they relate to liability for an omission. It's all about liability for an omission to act, to abate a problem that has arisen naturally or by a third party. Obviously, negligence doesn't typically impose liability for omissions. And also, whether a defendant is liable can depend on the personal characteristics of the defendant to deal with something like a natural hazard, including its resources. That's obviously a stark contrast with negligence, which tends to test a defendant's conduct by reference to the reasonable man.
Yes.
Just above F, he says that we're concerned with the liability of a person where nuisance has been created by one for whose actions he is responsible. Here, as I've said, it is still the law that the fact that the defendant has taken all reasonable care will not itself exonerate him from liability. The relevant control mechanism now been found with the principle of reasonable user, but it by no means follows that the defendant should be held liable for damage of a type which he could not reasonably foresee, and the development of law and negligence in the past 60 years strongly point towards the requirement that such foreseeability should be a prerequisite of liability in damages for nuisance, and then there's a reference to Wagon Mound too. So the principle of strict liability in nuisance is tempered by the fact that the harm must be reasonably foreseeable. But my central point is that reflecting the fact that the object of nuisance is the protection of the rights of landowners, nuisance at its core imposes strict liability. So then the question is, for the purposes of imposing in nuisance strict liability, what is to count as an interference with the rights of a landowner to enjoy its land? And that is complicated by the fact that we can't simply think of a single owner of land, because the uses of neighbouring landowners often conflict. So my right to enjoy my land is qualified by my neighbour's right to enjoy his land. My neighbour's right to enjoy his land is qualified by my right to enjoy my land. And the law of nuisance reconciles the rights of neighbouring landowners by applying the standard of ordinary use of land to determine whether the rights of an owner of land have been infringed. And that has two aspects. The first aspect, which I've been referring to, is that an interference with land is capable of being a nuisance only if it gets over the threshold of creating a substantial interference with the utility and amenity value of the land. And in that regard, the law is not concerned about any particular use of land. It's a more abstract concept. And we can see that going back right to the earliest case in the bundle, Divider 1, Walter and Self.
Sorry, this is still your third point?
It's still my third point.
Yeah, okay.
Yeah.
So, sorry, get back to where?
It's Divider 1 of the bundle. It's Walter and Self. So this is a 1851 case. The plaintiffs as the freeholder and tenant of a house in Surrey complained about the defendant making bricks on neighbouring land by burning clay. So it's a burning of bricks case. And they complained that the smoke and smell was a nuisance. And the Vice-Chancellor held it was a nuisance. And at page 8, we have a famous description of the test. So the first full paragraph on page 8. 6 lines in, the judge says that both on principle and authority, the important point next for the decision may properly, I conceive, thus be put. Ought this inconvenience to be considered, in fact, as no more than fanciful, more than one of mere delicacy or fastidiousness, as an inconvenience materially interfering with the ordinary comfort physically of human existence, not merely according to elegant or dainty modes and habits of living, but according to the plain and sober and simple notions amongst the English people. And that's the bit that's quoted in all textbooks. But I would like to draw your attention to is in the next paragraph, 5 lines up. For as I have said, they have, I think, established that the defendant's intended proceedings will, if prosecuted, abridge and diminish seriously and materially the ordinary comfort of existence to the occupying inmates of the plaintiff's house. He says, whatever their rank or station, whatever their age, whatever their state of health. So whilst he's not using the modern formulation of the substantial impact on the utility and amenity value of the land, he's abstracting from what is in fact going on the land to arrive at a sort of objective test. So next, if we could look at page 32, so divider 32 of the Bundle of Authorities. This is Southwark and Tanner.
Still part of your point 3.
Still part of point 3.
Sorry, we're 32.
It's divider 32. It's Southwark and Tanner. I really probably just need you to take you to page 571. Where in Lord Hoffman's speech, he says, I turn next to the law of private nuisance. I can deal with this quite shortly because it seems to me that the appellants face an insuperable difficulty. Nuisance involves doing something on adjoining or nearby land which constitutes an unreasonable interference with the utility of the plaintiff's land. And then if we could go actually back authority, it's divider 31, Hunter and Canary Wharf. So this is again Lord Hoffman.
Yes.
Page 537. And if I could invite you to read on page 537 from letter E over to letter D on the following page.
Sorry, starting at which letter?
It's letter E.
Thank you. Yes.
So page 537 at F, the learned judge explains that because nuisance involves causing an injury to the land, that happens if its utility has been diminished by the existence of the nuisance. And therefore, the way of quantifying damages for a nuisance is the diminution in the value of the land. If there's a permanent injury, it'd be the diminution in capital value. If there's a temporary injury, it would be perhaps a diminution in the rent you could, notional rent you could obtain for the land. But the learned judge notes at the top of page 538 that consequential damages can be available, amongst other things, for damages to chattels. Divider 43 is Fern. Page 949. Lord Legate giving the judgment of the in the majority says at paragraph 9 in his classic article, The Boundaries of Nuisance, Professor Francis Newark described private nuisance as a tort to land, by which he meant that its subject matter is wrongful interference with the claimant's enjoyment of rights over land. And then paragraph 11, he says it follows from the nature of the tort of private nuisance that the harm from which the law protects a claimant is diminution in the utility and amenity value of the claimant's land.
Yes.
Nuisance protects not only freeholders, leaseholders, my learned, as Lord Justice Nugee pointed out, people in possession, but also dominant owners of easements, and a particularly clear illustration of how the threshold test for a nuisance is applied by reference to an objective test relating to the utility of the land rather than any particular use of the land is provided in rights of light cases. And at divider 29 we have a rights of light case.
Sorry, divider
29. Page 460 of the judgment of Mr. Justice Millett. Letter E says interference with page 460. Interference with the right constitutes a tort of nuisance. The question in every case, therefore, is whether there's been such a substantial interference with the use and enjoyment of property by the dominant owner that it constitutes an actionable nuisance. Then the next paragraph, the dominant owner's right of light is not measured by the particular use to which the dominant tenement has been put in the past. The extent of the dominant owner's right is neither increased nor diminished by the actual use to which the dominant owner has chosen to put his premises or any rooms in them, for is entitled to such access of light as will leave his premises adequately lit for all ordinary purposes for which they may reasonably be expected to be put. The court must therefore take account not only of the present use, but also of other potential uses at which the dominant owner may reasonably be expected to put the premises in future. And so in a rights of light case, the same test is applied to determine whether there's been a substantial interference with light. It's the Waldron methodology, but it applies irrespective of the use to which the premises are actually put. So then we ask ourselves, how do you apply these principles where you have a sensitive person or business who is a claimant in a nuisance case? And there's a good illustration of that at divider 27 of the bundle. This is Ems and Pulver. The plaintiff was a playwright and especially sensitive to noise, and he alleged that building works to a neighbouring property were a nuisance. It's not a full judgment, but Ploughman held that the defendant was liable in nuisance, and you'll see at page 443 in the second paragraph starting the law, about 7 lines down, he says, first, there was the question whether the noise was such as materially to interfere with the ordinary comfort physically of human existence in the plaintiff's premises, according to plain, simple and sober notions amongst English people, or whether it affected the plaintiff only because he was hypersensitive to noise, if indeed he was. So that's sort of second paragraph starting the law applicable to proof.
Okay, yes.
About halfway.
Yes. First, did you...
Exactly.
Yeah, okay.
Or whether it affected the plaintiff only because he was hypersensitive to noise. Then the next paragraph, the judge says that the plaintiff was a playwright, 43 years of age. His work was creative work, requiring a high degree of concentration. His study where he worked was bounded on one side by the party wall. Although he said he was not unduly sensitive to noise, the judge took a different view about that. He thought that the plaintiff expected and felt entitled to a high degree of quiet than an ordinary man who had a flat in a residential part of Hampstead would expect. But making every allowance for that, he was nevertheless satisfied on the evidence as a whole that the degree of noise occasioned by the defendant's operations was such as to constitute a nuisance within the definition. So you apply the correct test, but if applying the correct test, the claimant is sensitive, is operating a sensitive business. Nevertheless, he wins.
Can you help me with the philosophy? What's behind this? Is it saying that the plaintiff, in using his house as a study, that was an ordinary use, was it? And he just happened to be unduly sensitive, but there was still a substantial interference with his ordinary use. Is that how you get to this?
Exactly. The claimant was unduly sensitive, but applying the test of whether there was a substantial interference with the utility and amenity value of the land, there was.
Yeah.
So he succeeded.
Yeah. Okay.
And indeed, it seems that a claimant with who is operating a sensitive business on its land is entitled to remedies specifically protecting or vindicating that sensitive business.
So it's a matter of damages or quantum or whatever.
Yes, and as long as you've established a nuisance.
Yes. So can I just run it through to make sure I've got it? So it's a sort of objective approach. Is there a substantial interference with a common or ordinary use? Is what you're looking for. It's a predicate. And in looking at that, you say you disregard sensitivities. You just ask whether there's an interference with common use.
Yeah.
It's a fact find for the judge.
And also abstracted from any particular use. It's a
it's not actual use. It's a sort of more objective standard. I think is how you proposed it. Fact find for the judge. But if the claimant gets over that hurdle, you then do look at sensitivities when it comes to issues of remedy.
That seems to be the case, and there's a Privy Council case providing authority for that, which is at divider 45 of the bundle.
Do you want us to go to that?
Yes, please. It's
Right.
McKinnon Industries and Walker.
It's the orchids.
It's the orchids case. So the defendant manufactured products for the car industry. The claimant grew orchids on neighbouring land. And the defendant's works caused smoke, vapours and noxious matter to be deposited on the claimant's land, which caused trees, hedges, flowers to sicken and die, and also killed the orchids. The trial judge, this is in Ontario, granted an injunction, held the defendant liable and granted an injunction to restrain the defendant from depositing material on the claimant's land. And all of that was upheld in the Privy Council. And at page 1033, at the foot of the page,
Yes.
right at the foot of the page, says, then it was contended by the defendant that at least the injunction should be modified so as in some way to exclude damage to orchids from its operation. The ground of this contention was that the growing of orchids is, from the horticultural point of view, a particularly difficult and delicate operation. But however this may be, and their lordships express no opinion of it, there's no reason to treat damage to the orchids differently from damage to any other flower, plant or shrub. When the wrongdoer admits, as the appellant company has admitted, that it is violated the respondent's legal right by damaging his orchids.
So it's a sort of, this is a bad analogy, but I'll try it. It's a sort of eggshell skull rule that you take your victim as you find them, and if having inflicted on them an objectively assessed nuisance,
Yeah,
you take what comes.
that's right. As I understand the eggshell skull rule, it kicks in
They find those.
not at the time you ask yourself whether there is liability.
But when there's a breach of duty.
When there's exactly.
That's right.
Finally, divider 50. So the High Court in Australia has recently decided whether fern represents the law in Australia. Related to whether the building of a tram system in Sydney was a nuisance. And the court divided 3-2 in this case. And just as the division in the Supreme Court in Fern, the majority thought Lord Leggett was correct in his statement of the principles of nuisance. The minority thought that Lord Sales was correct in his view of the law of nuisance. So the outcome of this is that Fern is the law in Australia. For our purposes, I want to take you to page 1190. So this is from the judgment of Justice Beach Jones, who was in the majority thinking that Lord Leggett got it right in Fern. Paragraph 275, just going to the point, the judge's suggestion that unless the sensitivity principle could be qualified, people with sensitive businesses wouldn't be protected. You'll see 5 lines in, he says, parties who use their own land in a manner that is not common or ordinary do not become outlaws so far as the protection of the law of private nuisance is concerned. Instead, they merely do not gain protection for a substantial interference with that particular use of land at the expense of their neighbour's right to use their property as they see fit. The protection for common and ordinary uses of their land still subsists.
That sort of suggests that a special use and a common use are necessarily alternatives, but they might not be. They might be.
Yes.
I find that
Yeah. That's not a brilliant description, but that is correct.
Life is a bit more complicated than
It
that.
is more complicated than that. Okay, so I'm still on my third point. I am going to bring it together reasonably soon. So trying to explain how the law of nuisance protects the rights of landowners by reference to the ordinary use of land. It does so first by imposing a threshold test by reference to the utility and amenity value of the land. And the second way it does that is to say that even if a neighbour's activity does interfere with the utility and amenity value of my land, that is not a nuisance if my neighbour's activity is for common and ordinary purposes, and if it is conveniently done, i.e. with due consideration for neighbours. And this is vital. Basing liability for nuisance on the idea of ordinary uses of land creates a symmetry in how the law of nuisance upholds and protects the rights of neighbouring landowners. Each landowner's ability to use their land is protected by the fact that their neighbour cannot substantially interfere with the utility and amenity value of his land unless the neighbour is putting his land to a common or ordinary use conveniently, and the landowner enjoys a right to make a common or ordinary use of his land, so long as it's done conveniently. And this is dealt with by Lord Legate in Fern. It's again divider 43 of the Bundle of Authorities, page 957. And it's paragraphs 34 and 35, and I invite your lordships and your ladyship to read those paragraphs.
Yes.
So I'm going to take you to Ernest Weinrib's book, referred to at the end of paragraph 34 in a moment. But before I do so, I perhaps should have taken you, well, I should also take you to page 953. Where Lord Legate says in paragraph 24 that fundamental to the common law of private nuisance is the priority accorded to the general and ordinary use of land over more particular and uncommon uses. And in Fleming and Hislop, the Earl of Selborne encapsulate this well when he defined a nuisance as what causes material discomfort and annoyance for the ordinary purposes of life to a man's house or his property. And you'll see at page 25, there's the learned judge approves Robinson and Kilbert and the South African case.
Well, yes. I mean, what he coming back to this because he deals with this at including 27. Up to 27 is he says there are two aspects of the core principle enunciated in paragraph 24. One is the occupier cannot complain if the use interfered with is not an ordinary use, and 27, the other aspect, is that even where the activity does substantially interfere with the ordinary use, will not give rise to liability. The activity is itself no more than an ordinary use.
Yes. So that is, as I said a moment ago, the second way in which the law of nuisance relies upon the idea of the ordinary use of land. So it's both in the threshold test of working out whether an interference is sufficiently serious to constitute a nuisance, you're asking yourself, has there been a substantial interference with the utility or ordinary use of the utility or amenity value of the land? But that's subject to the qualification that even if an activity does meet that threshold test, there is a defence to a defendant if they are using their land for common or ordinary purposes and are doing so conveniently.
Yes.
Divider 58 is Ernest Weinrib's book. So I'd like to take you to the passage that Lord Legate referred to. It's page 1307.
Yes.
Now, I'd invite you to read near the top of page 1307, the paragraph starting, however, the plaintiff's right to use the property, and then the next paragraph, which takes us just over the page.
Okay. Yes.
And the final two sentences, in my submission, are correct and important, that allowing the claims of the hypersensitive would be incompatible with the nature of property. Because, because use would depend on the individual conditions of everyone because use would depend on the individual conditions of everyone affected, it would be a contingency rather than an entitlement implicit in property. So, drawing together the threads on my third point, just to remind you, my third point is that the judge's qualification of the sensitivity principle undermines how nuisance upholds the rights of the owners of land. What I say is this, that the problem with nuisance protecting sensitive uses of land, even if carried out at a suitable location, that do not substantially interfere with the utility and amenity value of the land,
Yes.
is that it creates an asymmetry in the ability of neighbouring landowners to enjoy their land. The claimant is able to, and would expect to be entitled to, use its land for the sensitive use and also for all normal purposes. But the defendant is prevented from using his land for normal purposes to the extent that's required to accommodate his neighbour's sensitive business. And my fourth point now, the asymmetry that's created if a claimant in a nuisance case can rely on an interference to a sensitive business is illustrated very well by this case.
Sorry, is the fourth point the problem with protecting sensitive use is the asymmetry? Is that your fourth point?
My fourth point is that the asymmetry that is created if a claimant in a nuisance case can rely on interference to a sensitive business is illustrated by this case.
Yes.
So the breeding season in 2026 starts at the start of March, so maybe next week. The judge held that it lasts for 5 months from the start of March to the start of August. It's paragraphs 129, 195 of the judgment.
Sorry, 129, 195.
Possibly no need to look at them. It's just that the finding by the judge that the breeding season lasts for 5 months.
That's what's pleaded, it says.
I thought he thought there was any evidence for a couple of months. I mean, it may not matter very much, but I thought the evidence, the findings fell short of the pleading.
My understanding of the judgment is the judge held that
It was March.
my clients only were told it was 3 months, so whether they breached any duty fell to be determined on the basis of what they were told, which was 3 months. But my understanding of the judgment is that the judge thought the breeding season was 5 months. So maybe we could look at page 109 of the core bundle.
Yes.
So, sorry, first of all, page 106.
That was pleaded at the top. I see 129.
Yeah, so that's breeding season pleaded as the start of March, and that's pleaded by the respondents.
Yes.
And page 122.
Yes.
He says at the very foot of the page how I have not been persuaded that the breeding season was identified. I identified to my clients in this conversation.
Sorry, which paragraph?
It's right at the foot of the page 122.
Oh, I've got it. Yep.
Yeah, I've not been persuaded that the breeding season was identified in this conversation as being from March to August, as the respondent said it was. Martin's own evidence is March to May was identified as the most sensitive time. So reading that together, I understood the judge as accepting the respondent's case that it was a 5-month breeding season, but the appellants were only told that it was for 3 months. Judge seems to have preceded the respondents correctly identified the period of the breeding season.
Yes.
So that means that for most of the spring and summer, when an owner of property might want, for example, to carry out building works, the second appellant is restricted, if the judge is right, in what it can do with its land. And there are 3 categories of restriction, if the judge is right.
Yes.
First, to an extent that would be uncertain, even to an expert on falcons, with a good understanding of how the third respondent ran its business. The second appellant is prevented from putting things in the air.
Which paragraph is that in the judgment?
So, first of all, take you to the allegations relating to that.
Do we have a picture of the building?
I am just about to. So this is the point in the judgment where I'm taking us into the details of
Okay.
the findings. So I am about to take you to aerial photographs and
Thank you.
other. So page 83.
I should have asked how you're dividing up the time, the 2 days. Have you discussion?
I think I can speak for the response by saying that the parties think there is no difficulty with time. We've got plenty of time.
Right.
As an absolute backstop, we've agreed to finish by the latest by the end of today. But we're confident we'll finish before then.
Okay.
And again, as an absolute backstop, the respondents have agreed to give us an hour to respond tomorrow. But I suspect we'll finish way before then.
So page 83.
Page 83. So the allegations of nuisance arising from putting things in the air. First of all, paragraph 41(1). It's alleged from January to April 2022, a scaffolding business operated which generated an excessive noise, and including the operation of a truck-mounted crane 10 metres in height that broke the sight line of the falcons, constituting a visual threat. And the crane allegation of putting the crane in the air didn't succeed. But what did succeed in respect of putting things in the air is what we see at number 5, on 7th of April 2022, positioning a digger with its bucket raised in the air, constituting a visual threat to the falcons. And that did succeed. If you turn to page 161 of the bundle,
Yes.
if I could invite you to read paragraphs 385 and 389.
Sorry, just 385 and 389?
I think you probably need to only read paragraphs 385 and 389.
Can I just ask, I've got in mind your formulation. Is it relevant at all? Because I think where the judge was going on this was, I think, to say that these acts weren't done in isolation, they were done in the knowledge that they would distress the birds. Do you say that's something that falls out of account altogether?
So we're not challenging the judge's findings that doing the things that my clients did on their land foreseeably harmed the falcons.
But what I'm asking is, where does it fit in the formulation of nuisance? Because at the moment we're on your point that says that this case illustrates the very points that you've been making on the case law. The case law that you've taken us to is all about the objective use of land on both sides, and you look at it at 2 points: the threshold and what the defendant's doing with their land. I think where this comes in, I just wanted to understand where you put it, is the judge's analysis that whatever the defendant does with their land, it has to be a convenient way of doing it. And the judge had found that your clients knew that these things would upset the birds. And I'm really asking whether that fits in at all to the analysis.
So the judge got nuisance. First of all, he applied the wrong threshold test. Should have applied the test of the utility and amenity value of the land. If we're wrong about that, we then go on to the point that he should, even if we'd hit the threshold test, he should have held that there was a defence on the grounds that my clients were using the land for common and ordinary purposes, and were doing so conveniently. And for that purpose, it conveniently doesn't mean accommodate a sensitive business.
Understood that, but I suppose, I think I've got that on board. I know I've got that on board. Just really to put it the other way around, that if your client knows that these actions are going to upset the birds, you say, well, that's got nothing to do with anything, because their only obligation is to use their land for ordinary purposes conveniently and not to safeguard a sensitive business.
As in Robinson and Kilbert.
Even if they know it's sensitive.
If you remember in Robinson and Kilbert, what was sought was an injunction. So they're looking to the future at a point where the landowner would have known that continuing to heat the seller would have interfered with the business.
Okay, thank you.
Page 122 of the supplemental bundle.
Sorry, page
222.
Thank you. Yes.
So edged in red is the second extent of the second appellant's land.
Yes.
Coloured in blue is the scaffold yard, and it was approximately there that the digger was positioned with its bucket in the air. And edged, I think, in green is the position of the aviary.
Yes.
Page 240 is the digger with its bucket in the air, which was held to be a nuisance. So I think this is a photograph taken by the respondents showing the digger waiting to be repaired whilst it was alleged to be causing a nuisance, with the aviary situated to the right, behind what seems to be the boundary fence.
That doesn't look quite in the scaffolding yard.
It's not quite there. I think it's a little north of the
Yes.
scaffolding yard. But I mean, I mentioned in saying passing that the idea that an owner doing this on their land is unlawful is ridiculous. So at page 68 is the digger being taken away to be repaired.
Sorry, it's 68.
68.
Hold on. Yes.
And if we want to know exactly where the digger was, page 66, this is a map annexed to Mr. Hode's witness statement, and the position of the digger when being repaired is marked by the cross on the plan. Now, I think the boundary feature with the aviary land is just to the right of the cross.
Yes.
Now, if the judge was correct that the digger with its bucket in the air was a nuisance, we can say that there will be lots of other things that will be a nuisance because they involve things being put in the air. If you could turn to page 29, this is from Martin Nicholas's witness statement. 29. He says in paragraph 45 of his statement that falcons are sensitive birds, but geofalcons are known to be incredibly sensitive and interpret many things as a threat, which could be anything that the falcons do not usually see or hear on a daily basis. And then 4 lines up, he said, the sight of a crane or even a kite on a string that appears above the sightlines of their pens could scare the birds and cause them to become stressed, as it's not something that they're used to seeing. And in paragraph 47, second sentence, you say, by way of example, fireworks would scare the birds in 2 ways. One is noise. This is something they're not familiar with. The other is visual. once they link the two together, it only makes the situation worse. So according to the evidence of Martin Nicholas, if the judge was correct, it looks as if the second appellant, it would be unlawful for the second appellant to fly a kite on its land. It'd be unlawful for the second claimant to use a crane on its land, at least if it interfered with the falcons, and unlawful to set off fireworks, even if silent, because they might be seen by the falcons.
Is this 45? Is this time limited, or is this said to be at any time?
Well, the respondent's case at the trial, as I understand it, was that they are sensitive at all times, but particularly during the breeding season.
Right. I mean, this doesn't say. This just says incredibly sensitive.
48 refers to fireworks night, which is November. His friend's birds.
Yeah, I think their case was particular. I think that comes from the pleadings, actually.
And the actual particulars of nuisance are all between January and April. So it does include outside the breeding season. There's an allegation, but I think, did you say the judge did not accept 20A from January to April operating scaffolding business, excessive noise, or did he? I remember.
There was a finding of nuisance in respect of noise from the scaffolding business, but not in respect of the crane.
The sight line. But
only because it didn't break the sight line of the falcons.
But that is from January to April.
I thought he didn't.
And it was, I'm grateful for my learned junior, the allegation was proven only in respect of the months of March and April.
The bucket allegation.
I think the scaffolding.
The noise.
The noise, the scaffolding. Yeah, the bucket operation relates to the barn works. And
was that based on the judge's finding that your client had only been told that March to, which was it? March to May was the relevant period? So he gave us the paragraph before and I've now forgotten it. Yes, it's paragraph 195. February to May was identified as the most sensitive time. So what was the judge's finding in respect to A? What was it again?
Allegation 1 is on page 158.
Thank you.
And it's limited to March and April, because that's the breeding season.
I think my learned friend Junior is saying, I think what the judge said, that the duty in both nuisance and negligence was limited to the breeding season,
Right.
because that's when the falcons were especially sensitive.
So they're incredibly sensitive all the time, but particularly sensitive during breeding season.
Yes, that's what the respondent said. I thought there was a passage in the particulars of claim, which I haven't immediately been able to find, which says that in terms. Perhaps it's in a witness statement. But even confining itself to the breeding season, the second...
It all seems to be March through to May, so I was looking at the barn building, including the bucket, seems to be March, April, May, in terms of findings. Which isn't quite the same thing as breeding season, I think, is it?
No.
It's what the judge found.
Yeah.
Right, so you take us to 45.
45. The point I'm making is, if the judge is correct in saying, just thinking about things being put in the air, the judge is correct to say that the digger's bucket being put in the air is a nuisance. All kinds of other things could well give rise to liability and nuisance relating to things being put in the air. For example, flying a flag on their land. I mean, just imagine that. That's a sort of symbol of dominion and ownership of land and territory. Flying a flag on the second appellant's land would risk liability.
Is there a picture of the aviary itself?
Yes, so if you turn to the supplemental bundle at page 227, so the red arrows are the aviary, and the blue arrows are showing us the location of the barn being erected.
Sorry, I'm finding that rather difficult to visualise. It's got some things sticking up out of the top of it. Is there no closer picture?
So page 231, the aviary is kind of at the horizon of the picture, and to the right is the barn being constructed.
Don't find that very clear either. There's an aerial photograph at 226, which gives you an aerial view of the aviary.
Oops. What I'm trying to work out is where are the sort of windows, or what is the line of sight? Is it looking? I can't. What are those round things?
So
Is it completely open?
So
Obviously there are pens, but
two perhaps, first of all, 245 is perhaps a better picture of the aviary.
Sorry,
245. So you can see the aviary on the left.
That big barn behind the blue thing.
Yeah, exactly. Just beyond the blue thing.
There's also 244, which But to pick up my Lord's question, none of these really illustrate what the line of sight from the pens
Well,
is.
I was also going to take, there's the plan of the,
The plan attached to the judgment.
oh, that's right. So there's a plan attached to the judgment at page 192.
yes.
And so the pens on the left-hand side were the ones which were affected by the activities on the second appellant's land, and in respect of which the harm was caused. And as I've understood it, there were sight lines in that wall of the aviary. But having said that, if you could turn to page 80 of the core bundle.
Yes.
Paragraph 25, just over halfway down, the judge says, on the site visit, I could see the modification of the western pens.
Sorry, wait a minute. Just got it.
And then you see the rest of the paragraph.
Sorry, what paragraph do you want us to just look at?
It's paragraph 25. It's a modification in which the west-facing windows are closed off. So before that, there were windows facing west, which is where the digger was.
So we don't know whether these photographs were before or after that modification.
I don't, and of course the modification to the sensitive third respondent's business raises a whole series of other questions about the approach adopted by the judge. If you have a duty of one sort or another to accommodate a sensitive business on neighbouring land, what does that tell you about the position in circumstances where the sensitive business can itself take steps to entirely avoid or minimise the interference? And that was an issue in the Cape Town case where, if you remember, the issue was ultimately solved by putting a different cable in. But on the hard-edged property law approach taken by nuisance, that doesn't arise.
Is that a convenient moment?
Yes.
So we'll start again at 2 o'clock.
What, right on the table?